Madam Clerk, would you open the courtroom, please?
The State of Michigan 36th District Court is now in session. The Honorable Judge David S. Robinson Jr. presiding. Good morning, everyone.
Good morning.
You've reached Attorney Tom McCut with Burns Associates. I am
All right.
currently up.
On the record, in file number 20156-234, RMF Asset Management versus Joy Barnes. The parties have appeared and I have placed them in a breakout room at this point. So we're waiting for them to see if they can resolve their case. We back on the record. Ms. Barnes, turn your sound on.
Yes.
All right, we are back on the record on file number 2015623 RMF Asset Management versus Joy Barnes. You folks have had an opportunity to go to a break room. Were you able to resolve the file?
Yes, Judge. Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record.
Okay.
Your Honor, we were able to resolve this matter. I'm not sure how Your Honor wants us to submit a judgment. If we can do it under the 7-day, the defendant has basically agreed to a consent judgment for the full balance with monthly payments of $100 per month beginning March 1st and by the 1st of each month thereafter.
Is that your agreement, Ms. Barnes?
Yes, sir.
All right, then what I will do is, the terms of the agreement having been placed on the record, I will dismiss the case without prejudice, and I'll look forward to your closing paperwork.
So you'd rather have us send it to the defendant to have her sign it and then submit it to the court?
Yeah.
Okay.
Meantime, I'll just go ahead and I'll dismiss it without prejudice based upon what you placed on the record today.
Thank you, Judge.
Thank you both for coming in. We're off the record.
Thank you.
All right.
Thank you. Have a good day.
Have a good day.
Good day to both of you. All right, they're good. All right. So that's done. Stop the video. Great. Mr. Barter,
Good morning, Your Honor. How are you, sir?
good, how are you? You're here on the portfolio recovery versus Tony Weatherspoon matter?
That is correct, Your Honor.
Okay, I don't have Mr. Weatherspoon yet. Did you get an answer to your motion for summary disposition?
I did not, Your Honor. I think the last time we were here prior to it being adjourned because of the court being closed, I thought it was pretty clear that we adjourned it so that Mr. Weatherspoon could file that response to our motion. I thought maybe he didn't know he needed to serve us and hopefully sent it to you. Obviously, you're telling me that did not happen as well.
We have no response at all. I'll put you back in the waiting room. I'll check one more time with my clerk, and then at 10:30, we'll be prepared to proceed.
Thank you, sir.
Now, let's see, how do I do this? Do-do-do. I have forgotten how to put you back into the waiting. Oh, here it is over here. That's not it. Mhm. Now let's talk here. What's the number? So this. What is your name? What is your name, sir? Mr. Kennedy, what is your name? Tanisha Kennedy?
Yeah, Tony Witherspoon.
You're Tony Weatherspoon.
Yes. Yes, Your Honor.
Sir, we almost started without you. This is a 10 o'clock matter, and you
Yeah,
came in.
I just got,
Yeah. Let's get started.
Yes, sir.
Mr. Bronner,
Yes, sir.
let's call our file and begin. This is case number 1918361. The file is entitled Portfolio Recovery versus Tony Weatherspoon. We are here today on an adjourned motion for summary disposition. Motion for summary disposition was filed on behalf of plaintiff in this matter on or about September 15th, 2020. The matter was scheduled for hearing on November 24th and had to be adjourned today because of the court's closing. Your respective appearances.
Good morning, Your Honor. Cezanne Barta, P65425 on behalf of the plaintiff.
And what is your name, sir?
Tony Witherspoon.
Mr. Weatherspoon, did you file a written response to this motion for summary disposition that
Yes,
was
I
filed
did.
on September 15th?
Yes, Your Honor.
When did you file it, sir?
It's been a long time ago. This has been going on for so long.
Sir, that's not my question. The
Oh,
motion that brings us here today was filed on September 15th. Did you file an answer to that motion, sir?
yes.
When did you file your answer?
Oh, I'm not sure of the date.
Did you serve the other side, sir?
I don't understand.
Did you send a copy of the
I
motion?
filed it on August the 19th.
That was to the previous motion. That motion was heard and denied on August 26th. Then thereafter, another motion was filed, and that's the motion that's up for hearing today. Did you file a response to that motion, sir?
Yeah, please, Your Honor, this is the same motion. So I'm relying on the first response.
All right, fine, we'll proceed. Mr. Bartle,
Your Honor, this is plaintiff's motion for summary disposition pursuant to MCR 2.116C9 C10. There's no genuine issue of material fact to move forward. As you know, this is a straightforward collection matter on a credit card that was originally issued by Comenity Bank. It was purchased by Portfolio Recovery Associates. Attached to our motion for summary disposition is the chain of title documents showing how it went from Comenity Bank to Portfolio. Normally, we have an affidavit from Portfolio only, but in this case, we also have an affidavit from the owners of Comenity Bank saying that this was one of the accounts that was transferred over. The redacted line item that shows all the information from the defendant is one of those accounts that went over to Portfolio Recovery Associates. We also have billing documents that were mailed to the defendant that shows that he used the card and that he made payments on the card. I also have an email from Portfolio Recovery saying that they were in contact with Mr. Weatherspoon on January 22nd, 2019, and he verified that the PO box is correct, but he requested that we do not use it and verified the CADU address, which is where the billing statements were going and the payments were made. But he hadn't lived there in about 6 to 8 months. On another call a month later, on February 4th, he provided his new address. And so they were in contact with Mr. Weatherspoon. I know he's saying that he has no idea about this PO box address that we're talking about. So I don't believe there's a genuine issue with tech moving forward. I don't know, to be honest, because we never received the first answer to the motion for summary, whether there was a counter affidavit pursuant to Michigan court rules. However, at this time, Your Honor, I don't believe there's a genuine issue material fact to move forward to trial. I believe we have all the documents attached to our motion that show that this account was opened, used, payments were made, and that there's a balance that's owed.
Mr. Weatherspoon, your response.
I object.
Yes, sir. What do you want to tell the court?
I never signed nothing. And I ain't received. And I ain't have a receipt, I haven't received no credit card. And I ain't made no payments. I ain't got no idea what the PO box is. I really don't know none of this is my doing.
All right. The court's prepared to rule on this matter. This matter was originally before the court for hearing on August 26, 2020. At that time, the motion for summary disposition was denied, plaintiff having failed to appear for plaintiff's motion. The order denying the motion for summary disposition noted that the defendant had filed an answer to the motion and appeared via Zoom. It appears that no additional motion, no answer to the motion for summary disposition has been filed by Mr. Weatherspoon, who indicated that he will rely today on the motion on his answer that was previously filed. That answer filed with the court on or about August 19th of 2020 contains no counter affidavit. The court rule, Michigan Court Rule MCR 2.116G41 was quite explicit. When a motion for under sub rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavit or otherwise provided in this rule, set forth specific facts demonstrating that there is a genuine issue for trial. There was an affidavit here that was supplied by the plaintiff along with the plaintiff's complaint. In addition, a subsequent affidavit was filed by plaintiff. There are no counter affidavits filed on behalf of the defendant in this matter. Court rule is clear. You cannot meet affidavits by simply mere allegations and pleadings. The court finds there is no genuine issue of material fact. The motion for summary disposition filed on behalf of the plaintiff in this matter is granted under C10, there being no genuine issue of material fact. Mr. Barter, you will submit your proposed judgment under the 7-day rule. Mr. Weatherspoon, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. Thank you, gentlemen, both for coming in. We are now off the record.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. All right.
August, February 14th at 10.
The ultimate question yet unanswered, are we alone in the universe? A Harvard astronomer theorizes it's possible we are not. In his
All right, let's get started. All right, Ms. Navy, why are you here?
Good morning, Your Honor. I'm here on behalf of the city in the Detroit Anesthetics with the underlying group versus City of Detroit. Underlying claimant is Karen Brownlee.
All right, who's here on that file? That would be,
I'm here on that one, Your Honor.
all right. All right, so then, Mr. Stratton and Mr. Woolen, you're off to my waiting room. All right. This is case number 19181-744, Detroit Anesthesia versus City of Detroit. Motion filed on behalf of the plaintiff to reinstate the case after plaintiff failed to appear for pretrial, a pretrial for which plaintiff acknowledges receiving a written notice. Your appearances.
Good morning, Your Honor. Ian Coote, 73154 for the plaintiff.
Good morning, Your Honor. Lauren Amy on behalf of the defendant, City of Detroit, P80726.
Why should I reinstate this, Mr. Coop?
Well,
You didn't show up.
Yep, and we didn't, and I apologize. There is good cause, though.
Which
as
is
I'm
a
sure
good cause. You say you got the notice. I don't understand a good cause.
Well, Your Honor, at that time, this was back on August 27th. Now, at that time, we were transitioning back to working in the office from working at home. And then I believe right about that time, we stopped trying to get people back in the office and pushed them back to their house, their working from home. So it was things were sort of in flux at that point, and you know, we were doing our level best to get to things, to get them on the calendar appropriately. And this one looks like it just slipped through the cracks. It certainly wasn't intentional. It wasn't you know, for lack of trying on our part. It's just the resources in the office were spread pretty thin at that time, as I'm sure many offices were. Also, in terms of the prejudice to the plaintiff, all the dates, if we did refile, would be barred by the year back rule. As to the prejudice to the defendant, I don't imagine that they're going to be unable to, you know, get prepped for trial. I would imagine that the trial set in this matter is probably not realistically going anyway. It'll need to be adjourned. So I don't believe that time is going to be a factor in terms of prejudice to the defendant. However, the time would prejudice the plaintiff because of the year back rule. And that, in a nutshell, is our argument, is that we knew we were supposed to be there. We make no bones about that. We just missed this on our calendar.
Ms. Name.
Yes, Your Honor. You know, at this time, we haven't received any discovery. Obviously, we didn't get any. So, you know, I would defer to you as to your decision on regards to the plaintiff's motion.
Counsel, if you don't want to say anything, just say you don't want to say anything. You defer to me. It's always my decision. Everybody who's wearing a robe, raise your hand. Those are people who make decisions. If you want to punt the ball, just say you want to punt the ball. All right, this is the ruling of the court. This sounds like a situation in which defendant has not and will not be able to demonstrate any prejudice other than the time wasted for the defendant appearing for the pretrial. The plaintiff did not. The court will therefore grant the motion to reinstate the case. As a condition preceding for that, counsel for plaintiff will pay attorney fees in the amount of $250 to the defendant. That amount to be paid within 14 days of today as a condition precedent to reinstating the case. And so the next thing we'll do is we'll give you a new date, and your next date will be March 8th. Does that date work for both of you?
It does, Your Honor.
Yes, Your Honor.
All right, March 8th at 11 o'clock will be our next pretrial. You'll get two orders. There'll be an order granting a motion to reinstate condition upon the paying of the $250. You'll get a notice for the March 8th pretrial. I will send out again with that March 8th notice requirement that you folks make the 2.306 disclosures within 21 days of today, but that'll be all on the written notice. Anything else we can accomplish today?
Nothing for me, Your Honor. Thank you.
Thank for you.
Thank you, Your Honor.
All right, let's be a little more careful about our paperwork, folks. That's how we move. Thanks for coming in. We're off.
Thank you, Your Honor.
Thank you, Your Honor.
Oh. Stop video before he left. Idiot. We are on the record calling file number 2016056. The file is entitled Dearborn Total Automotive versus Ariana Fleming. By notice dated January 8th, is matters before the court today, February 1st, on the motion to reinstate the case filed on behalf of the plaintiff. The matter scheduled at 11 o'clock is currently 11:30. This matter was previously before the court, scheduled for a pretrial on October 27th, 2020. At that pretrial, a Zoom hearing, the defendant appeared, plaintiff failed to appear, and the court dismissed the matter without prejudice. Your appearance.
Yeah, good morning, Your Honor. Trevor Stratton, P65124, on behalf of the plaintiff.
Mr. Stratton, have you heard from the other side here?
I have not.
Okay, have you gotten any written response from the other side? I'm asking because the other side did appear at the pretrial, and we did
Right.
see notice, obviously, of today's motion to the other side. Have you received any pleading from the other side?
I have not.
Sir, your motion.
Your Honor, my motion, I don't really have anything to add beside what was in my motion. It was simply a matter of I put the pretrial in my phone for the 29th. I don't know if you recall, I actually called in on the 29th and you told me, yeah, that was certain 2 days ago. So that was just a mistake on my behalf. I hope that the court will understand that and be able to reinstate the case. Defendant hasn't been prejudiced in any way. We can still proceed with the case in the same manner as if I had appeared at that time.
Yeah, the problem that I have here is that in the face of what appears to be a clerical error, I'm looking for some sort of prejudice suffered by the other side if I'm going to consider not granting the motion. The other side has not appeared, has not filed any kind of pleadings. Given that the matter at issue is really an account stated, it's hard to understand how there could be any prejudice to the other side to by reinstating the case. Therefore, your unopposed motion to reinstate the case will be granted. The file will be set down for pretrial. The new day will be March 8th. March 8th.
March 8th, I'm gonna write it down right now.
Write down March, not May.
Gotcha.
March 8th at 11 o'clock, we'll send out an order.
Your Honor, can I ask you briefly about another matter?
Sir,
I just
let
opened,
me end this matter
yes, absolutely.
in the YouTube, and I'll come back to you. Okay? So I'll
Yep.
put you in the waiting room for now. Then I'll end the YouTube, and I'll come back to you.
Thank you.